They laughed when she walked into court alone. What they didn't know was that every laugh would cost them millions. They laughed when she walked in alone. It wasn't a single sound so much as a ripple, a quick, practiced amusement that slid across the wood-paneled room like a ripple across glass. Damon Cross Morrison's laugh reached the farthest rows first, a low, certain chuckle that said, "I've hired the best. This will be over by noon." His team, immaculate in gray and navy, glanced at one another and shifted with the calm of predators who have already found the trail. Cameras at the back tracked the movement like eyes. Kesha Darnell Morrison paused in the doorway as if testing the air. The courtroom smelled of old paper and lemon cleaner. Light came through tall windows, outlining the mahogany in a way that made everyone in it look either very small or very important. She pulled the strap of a briefcase tighter against her shoulder. The navy suit she wore had seen better years. The hem was soft at the cuff, the fabric creased in a way the store-bought suits in the defense corner never were. There was a small fray near her elbow that hinted at habit rather than neglect. No hairstylist, no entourage, just her. 11 years of marriage had been built in the same measured, quiet labor that had stitched the fray in that sleeve. She had been in every late night, every last-dollar payroll scramble, every meeting where the whiteboard was more prophecy than plan. She had signed loans, chased invoices, calmed panicked engineers, and photocopied contracts at 3 in the morning when servers crashed and the company needed to reassure a client. Damon had given the speeches in polished auditoriums while she kept the lights on. The lightning round of a laugh ricocheted through the spectators and onto the bench. Kesha did not look at Damon. She stepped forward, eyes fixed on the judge's bench, and found Judge Patricia Okonkwo looking up with the even, quiet gravity that comes from years of separating facts from fictions. The bailiff's badge flashed, the echo of heels clicked and stopped. Gregory Whitmore had already risen to his feet. His opening posture was studied, a slight tilt, palms together, the practiced cadence of a man who made certainty sound inevitable. He introduced Damon as the visionary founder, the one who had built an $18 million cybersecurity firm from a basement server and a handshake. He framed the case not as marital strife but as common-sense business division. Kesha, he suggested with a shrug, the way people dismiss a cloud at the edges of a map, had played a supporting role. The number Whitmore offered for settlement sounded intentionally theatrical next to the valuation, a $50,000 check, meant more like a coin toss than recompense. Kesha had arrived determined not to be invisible. She had chosen to represent herself. That decision hung over her like weather. Some called it brave, others reckless.
To her, it was a seam of necessity. Attorneys were expensive. Damon's team oozed the kind of money that paid for precedent. But what no money bought was the exactness of memory and the stack of proof that lived in the worn briefcase against her ribs. She had carried those documents to the courthouse like a pilgrim carries a relic, close, guarded, and not to be shown until the time was right. Ms. Morrison will be proceeding pro se, the clerk announced, and the word was both a fact and a kind of challenge. The room murmured, some surprise, some pity. Damon did not lower his smile. Whitmore's lips remained the same set of confident stone. The opening minutes suggested the shape of the match, polished machine against underdog grit. For many in the gallery, the result looked written. Kesha's opening statement was not a polished theater monologue. It was a list of small truths spoken with unapologetic steadiness. She told them where she had been at 3 a.m. on certain nights, not as an appeal to pathos, but as a map of work done. She pointed to dates on invoices with a finger that betrayed neither tremor nor arrogance. She spoke about a $47,000 loan she had made when the company was still just a promise, about how no bank record existed showing anyone had ever repaid it. She told them about the first SBA application that bore her name as co-founder, how she had negotiated payroll out of the backseat of a car, how she had stayed when salaries were deferred and founders were small in the world's eyes. What was remarkable wasn't theatricality, it was precision. Where Whitmore spoke in confident generalities, a man who built a company, Kesha supplied the detail that put the building into blueprints. She spoke simply, the way someone who knows the work speaks. She made no broad claims about the future. She asked no favors. She asked only that the court look at what the paper trail suggested. And in the months leading up to the filing for dissolution, she said, voice low and steady, documents were changed, language was amended, names removed. She slid a photograph of a corporate filing across the table towards the judge. My name is on the original. The amended one shows otherwise. It would be easy to imagine this as a David and Goliath scene borrowed from courtroom drama. One folder, one tremor, silence. But the tension in that room was not made of myth. People there knew the stakes. They understood that $18 million was not only a number, It was the difference between an employee kept and a plan deferred. They felt for a beat the shape of months of small interactions finally being distilled for judgment. The first witness for Kesha was Isaiah Tumaine Wallace, a software engineer who had been at the company since an earlier, less glamorous phase. Isaiah wore his hoodie under a blazer and had the pragmatic tiredness of a person who had built features at midnight so the product could survive another day.
When he came to the stand, he did not give a dramatic account. He remembered what anyone who had shared long nights remembered: who showed up, who counted numbers, who took responsibility when money was short. He kept the payroll from collapsing, Isaiah answered when asked about Kesha's role, and his voice carried something that Whitmore's opening could not erase: the testimony of daily continuity. She wrote the checks, reconciled the accounts, she handled vendors when our CFO left. If anyone was co-founder in practice, it was her. Camille Renee Picker testified later, a woman who had signed grant paperwork with Kesha and spent years consulting during a crucial growth period. Camille's words landed like a different kind of proof. "I have emails from 2012 where Kesha is listed as co-founder," she said. "We discussed strategy, product pivots. She was at the table for the decisions that mattered." Small, concrete things stacked up: an email with the phrase co-founder highlighted in a subject line, a scribbled business plan that matched an SBA filing, a bank ledger with a $47,000 withdrawal annotated in hand. Each detail read aloud had the feel of puzzle pieces finally meeting. Opposing counsel tried the usual drills. Whitmore's cross-examinations were like practiced funnels, designed to reduce complexity to a narrower point of doubt. He asked questions that aimed to make memory seem unreliable, to make a $47,000 loan look like a personal favor, to render an SBA form as something drafted in a hectic moment and not evidence of sustained development. Damon took the stand later, confident and composed, his posture cultivated to temper any sting the testimony tried to inflict. He referred to himself as the primary architect of the company's growth, the one who raised capital and negotiated investor agreements. If he sounded certain, that certainty was born in rehearsed repetition. The early veneer of his testimony rode on phrases about vision, leadership, and the sacrifices that, when told in a certain way, make a person seem singularly indispensable. Damon was comfortable using the language of success. It was his native dialect. That comfort assumed a kind of inevitability that came with polished PR and years of being the public face of a company. Kesha's cross-examination, though, was different. She did not have the steady well of cross-examination technique to fall back on. What she had were details that had been gathered over years and stored across slips of paper, emails, and bank statements. She had the patience of someone who had been watching, noting, saving. When she asked Damon where records of the $47,000 repayment were, the question itself was the press of air in the room. The silence after it was not simply the court waiting for an answer. It was the air holding collective breath for some crack in Whitmore's polished defense. "There's no bank record," Kesha said. Her voice did not break. "No evidence a wire was made. No canceled check. We had a ledger and receipts. I covered payroll that week because we had to make payroll." She placed a copy of a ledger on the table with the same ordinary tilt as a person placing a plate down on a kitchen table. The ledger had dates, names, entries. It was ordinary. Ordinary is what sometimes undoes extraordinary claims. An email thread contradicted a version of events Damon had narrated. It had a moment when Damon, in a message, thanked Kesha for keeping things afloat in the early months. The email's casual tone made a loud, quiet thing, an admission hidden in the ordinary language of a team deciding who would take which roles. There was a visible shift in the room. Whitmore's jaw tightened. A juror-like murmur ran through the observers. The defense table no longer looked as impenetrable. It looked busy, uncertain for the first time. Confidence does not recover easily from detail that can be checked. The part of the day that would become a hinge began with a simple gesture. Kesha opened her briefcase and took out a manila folder. The camera angles at the back, the ones that would later show the moment again and again on evening news, lingered on a rough edge of paper and a single paperclip catching light. She slid the folder across the table, and the sound of it moving over oak seemed to slow the minutes. Inside was a packet of documents she had not let anyone see until that moment: early business plans, correspondence with an investor named Julian Cortez, payroll receipts, the original Small Business Administration filing listing Kesha as co-founder and chief financial officer. There were signatures, there were dates, there was a canceled check showing a $47,000 outflow at a time when the company had no other way to meet payroll. There were emails that threaded names together, her name in a subject line, company directive sent from an address she had used when the corporate inbox still felt small. She did not make a spectacle. She did not slam the folder on the table.
She laid it down with a kind of domestic care, like a person setting down a child at the dinner table. The prosecutor's bench leaned forward. The judge's face was the same evenness, yet she tucked a printout under her hand to read. Damon watched as if watching his own history, his composure slightly cracking, not from tears, but from the sudden rearrangement of certainty. The room grew quiet in a way that had nothing to do with the judge calling for order. Laughter died. The small grin Damon had worn with such confidence evaporated, as paper exposed a narrative he would have preferred remain in shadow. It was the silence of recognition, a recognition that the simple work of years, once recorded, could stand up against a narrative of singular creation. There is a particular sound that arrives in a courtroom when a pile of evidence lands plainly on the bench, the sound of paper settling into truth.
The hush afterward is not courtroom etiquette. It is the recalibration of every person present as they reconcile an image with new information. For Kesha, it was as if something within her that had spent a decade tucking receipts into envelopes was finally being acknowledged. For Damon, it was the first small loss of inevitability. But legal battles are rarely won in a single drop of paper. Opposing counsel moved quickly to blunt the impact. Whitmore objected, sought to impeach documents, to question chain of custody, to suggest mistakes. For a while, the exchange was technical, the kind of back and forth that makes headlines flatter than they appear in the room. Admissibility challenges, hearsay arguments, the quiet parsing of dates and signatures. The judge listened, asked pointed clarifying questions, and took certain items under advisement. Yet the packet had already done the work it needed to do in the gallery and at the defense table. It had altered perceptions. During a break, people clustered in small knots of conversation. Reporters scribbled notes with the intensity of people who knew a narrative had pivoted. Kesha retreated to a bench near the courthouse corridor. She sat with her hands folded, the briefcase at her feet. She did not allow herself to exhale fully. There was still a mountain of procedure ahead, a litany of witnesses, and the opaque machinery of discovery to navigate. But the small, hard work of gathering evidence, the ledger, the emails, the SBA application, had not only told a story, it had taken the floor and demanded to be heard. Outside, sunlight warmed the courthouse steps in a benign way that made the legal theater inside feel all the stranger. People shuffled by, some craning their necks to glance through glass at the proceedings. A cameraman adjusted a lens. A woman who had been in the front row approached Kesha with a folded paper cup of coffee and a single sentence. "You did what you had to." It was not praise so much as recognition. It landed against Kesha like a soft weight. The next stage of the day required patience, and unexpectedly, the arrival of more witnesses. Isaiah returned for more detailed questioning. He walked methodically through the fiscal history Kesha had outlined, corroborating entries and pointing out that certain payments had been logged under ambiguous account names. He explained, simply and plainly, how small companies sometimes used personal funds to fill payroll gaps, and how those moments of crisis could be the difference between staying in business and folding. When the ledger was placed under his view, he nodded and said, "That's the week we didn't cut payroll." Camille's testimony filled in the social pattern of business life. Meetings that had been convened at noon and dragged into dusk, investors who wanted vision threaded with profit, decisions that had been collaborative in practice even if records later success hierarchy.
She spoke about drafts of pitches and introductions to Julian Cortez, the investor whose emails had been among Kesha's documents. Kesha was always the one who translated tech problems into something investors could understand, Camille said. She knew how to make the numbers make sense. Whitmore tried to peel those moments into doubt, asking whether the forms had been filled in haphazardly or whether titles indicated formal roles. It was a skilled attempt to reduce an accumulation of small facts into a question of semantics. But semantics only goes so far when a ledger demonstrates recurring entries, when a series of emails shows consistent attribution, when a bank record shows a $47,000 withdrawal annotated in handwriting. Late in the afternoon, the mood in the room shifted in a way that was not dramatic but consequential. Damon took the stand again under a line of questioning designed to set his leadership in relief. He spoke of investor calls and meetings with testers, then paused at a question Kesha had prepared. It was not a show of aggression, it was a precise, unadorned inquiry into one narrow ledger entry. "Do you have a record of any repayment for the $47,000 loan?" she asked, voice even, eyes meeting his. He turned the question into an illustration of memory. He spoke of investments made, of advice given, of sleepless nights spinning strategy. Yet the question returned like a small, persistent clock hand. Where was the repayment? A carefully managed defense can sometimes hold even without documents, because audiences grant the benefit of the doubt to polished narratives, but polish cannot conjure canceled checks. Whitmore attempted to recapture control by introducing alternative explanations, relabeling the $47,000 as a guarantor transaction, suggesting it had been in advance, implying that business accounting often looked messy to outsiders. But the more those lines were drawn, the clearer the central pattern became. Kesha's record showed action that created value, and Damon's narrative relied heavily on articulation rather than the specifics of ledger and letter. At one point, the judge leaned forward and asked a clarifying question about a date on an amendment to a business document. "When was this amendment recorded?" she asked. There was a slight shift of posture in Damon that was uncharacteristic, a tightening at the jaw, a tilt of the head. The transcript later would show the judge's face as one of curiosity rather than suspicion, but curiosity is the small hinge from which suspicion, then consequence, often swings. The afternoon wound toward a recess. There was a feeling among those present that the match had shifted slightly. The polished confidence of the defense had acquired faint cracks, not because anyone had shouted an indictment, but because concrete, ordinary proof had been laid out in plain sight and had altered the court's mental map.
It is one thing to claim creative genius. It is another for the payroll ledger and an SBA filing to show who did the work in the trenches. Back on the corridor bench, Kesha allowed herself to let her fingers run over the worn leather of the briefcase. She remembered nights when a whiteboard held the version of the company's future they had all sworn to: a secure product, a loyal client base, the eventual meeting in a ballroom where Damon would speak and investors would nod. She remembered the first time she had signed a bank document that felt larger than she felt. She had been 30, tired, and determined. She had told herself then that the record of work would eventually speak for itself. Today it had, in a way she had learned to hope for but never expect. She had not yet won. There were more hearings, more documents to pull, and discovery to force from accounts kept in less visible corners. She had not yet reached the moment when a judge would set numbers in ink. She had, however, found an audience for the truth of small things: receipts, emails, a ledger. The courtroom's laughter had been replaced with a different kind of sound, a measured listening. As the break extended, a woman approached Kesha with a brisk step and a no-nonsense air. Her suit was a little too functional for fashion, the kind of wardrobe that said she valued substance over ceremony. Yvonne Baptiste introduced herself with a quick smile and a lighter-than-expected handshake. She had the look of someone who had argued too many cases to be flattered by drama. She was interested in facts and schedules and the oxygen of courtrooms. She had watched the morning and the afternoon, and when she spoke, it was with the economy of a person who recognized where things might be headed. "You're doing something difficult," she said. "You should have counsel on the record." She placed a card in Kesha's palm the way someone passes a contact, plainly and with intention. "If you'd be willing, I'll take a look." Kesha felt something tighten and loosen at once. The legal system demands patience. It rewards preparation. It sometimes responds to resources. Pro bono work is a quiet art of redistribution, of time, expertise, and access, and Yvonne's presence felt like a small rebalancing in a room weighed toward resources. It did not guarantee outcomes. It did, however, mean Kesha might not be forced to fight alone against a team whose hours were paid for by a different ledger. Yet that was further down the road. The immediate scene belonged to the falling of papers on the judge's bench and the hush that followed. In that hush, Kesha felt not the triumph of a vindicated martyr, but the simple relief of recognition. The court had, at least for the afternoon, turned its ear to the work she had done when no one was watching. She gathered her papers with the same calm that had carried her in.
The rest of the day would require more structure, additional corroboration, a tracing of accounts, a careful unspooling of amendments. But every good strategy begins by accepting what is true and making it visible. She had made visible the ledger, the SBA filing, the $47,000, and in doing so, she had forced a pause that the room had not expected. As people filtered back into the courtroom, the laughter from the morning felt distant and oddly brittle. Damon had lost something he had not known he could lose in a day that could still be rewritten by strategy and legal craft. The quiet that had followed the folder's arrival was more than the absence of sound. It was the presence of an uninvited fact that demanded response. The afternoon had shown how small things collect and how the ordinary is often the most stubborn form of truth. Kesha walked back into the courtroom with a gait that no longer seemed tentative. She returned not because she had won or because she expected to, but because the evidence had shifted the conversation. The court listened in a way that would make the next steps, subpoenas, discovery motions, the unearthing of entities that might hold assets, necessary. There was now work to be done that required patience, strategy, and allies. The next witnesses were called, papers were marked.
Yet beneath the procedural rhythm, something had cracked open. The idea that a life's work could be summarized by a press release and the name of one public speaker. The ledger, the SBA form, a $47,000 check. These were not cinematic props, but instruments of clarity. The defense would marshal explanations, but clarity can be the seed of accountability. When the court adjourned for the day, the energy in the room was different. Reporters lingered. People on the steps clustered and spoke in low voices, repeating details like a chorus learning words they had missed. A translator microphone hissed off. For Kesha, there was an odd small victory. She had walked in alone and left with someone else's laughter trembling like an echo, rather than a line of authority. She knew the battles ahead would be long. Damon had resources and a narrative that would not surrender itself without argument. There would be a need to uncover deeper records, the amendments to beneficiary lists, the formation of entities in Delaware, the small, sometimes invisible transfers that can change ownership without a courtroom drama. But for the first time, the court had paused. A silence had fallen that made room for a different sound, the slow, steady telling of what had been built together. At the elevator, a reporter asked if she had representation. Kesha turned the card over in her hand, then smiled, in a way that was not triumphal, but practical. "Not yet," she said, "but that may change." The silence that followed when the manila folder hit the table was brutal in its clarity.
It would not be the last silence in the story. There would be courtroom hushes and strategic pauses and the even colder quiet of a judge's pen. But it was the most immediate. The sound a room makes when a long-held truth is finally put where everyone can see it. For Kesha, it was the hinge between being dismissed and being heard. The next morning would bring fresh motion practice, new lines of questioning, and the unearthing of corporate amendments. For now, the briefcase at her feet felt like a ledger of small victories. She had manufactured none of them. She had only done what she had always done, saved receipts, kept records, and shown up when necessary. Today, those choices had the weight of evidence. She left the courthouse that evening knowing the file in her briefcase would be opened again and again. The work would require allies, legal know-how, and the peculiar courage of someone who must insist that their labor be counted. As dusk pulled over the city, she imagined a different kind of ledger, one that included future clients, a firm where other women would find a partner, a consultancy born of hard lessons. The thought was not escape, it was a plan, the kind of incremental imagining that carries people through long fights. For Damon, the folder's arrival had been a moment of unanticipated inconvenience. For the defense team, it had been a paper to be dissected and delegitimized. For the gallery, it had been the clean, startling moment when a narrative frayed. For Kesha, it felt like a door that opened onto work she had always known would need doing. Not the headline variety of victory, but the quieter work of ensuring the record matched the reality. Outside, the courthouse lamp cast a pool of light onto the steps. People spilled into the cool air, talking in small clusters. A passerby stopped, watched for a moment, then continued on their way. The city moved as it always did, indifferent and intimate all at once, letting the small triumphs and defeats of the day settle into the rhythms of ordinary life. Kesha walked past them holding a briefcase that was now heavier with new possibility. The laughter that had greeted her entry had not vanished. It had been replaced by something harder to define, a silence that demanded answer, a silence that once met with facts could not be dismissed. If you're watching, drop your city in the comments and hit subscribe. There are more stories like this coming. Yvonne Baptiste did not arrive like a television reveal. She arrived like someone who had been awake at 2 in the morning looking at spreadsheets and knew exactly where to put her finger down. That first conversation with Kesha at the courthouse bench was brisk and practical. Over a takeout dinner at a nearby diner, beneath fluorescent lights that made the coffee look serious, Yvonne asked precise questions and took rapid notes. She wanted dates, bank names, account numbers, the names of people who still remembered the early days. Kesha pulled the manila folder closer, and for the first time since the morning, let herself show how tired she was. "Documentation is everything," Yvonne said. "We can't rely on speeches. We'll need a paper trail that connects the dots. Ledgers, wire transfers, emails, amendments. If there's anything you don't have, tell me now. We'll find it." Finding it would demand patience and pressure. Yvonne knew how to run a case the way a carpenter knows how to read a plan. Measure twice, cut once, don't rush the foundation. She filed a motion to appear as co-counsel and asked for expedited discovery. The judge allowed her to join. The paperwork that made her participation official slid across the same mahogany that had once felt so hostile to Kesha. Once on the record, Yvonne began to use tools Kesha had not had: subpoenas, preservation letters, formal requests that required banks and third parties to turn over what had been tucked away. The discovery phase felt like an excavation. What looks tidy in a courtroom transcript is work that happens in dim offices over coffee with forensic accountants hunched over printouts. Yvonne brought one in, a woman with a calm voice who could read balance sheets the way other people read poems. She traced payments, followed account names, and watched for the small habitual tricks of asset movement: transfers with neutral names, LLCs registered in places chosen for their secrecy, amendments that quietly erased beneficiaries. The accountant's first headline finding landed on Yvonne's desk with the dull weight of inevitability. Cross Holdings LLC, a Delaware entity, held roughly $4 million in assets and had been the recipient of transfers from the operating company in the months prior to the dissolution filing. When Yvonne showed Kesha the screenshot of a corporate filing, Kesha felt a strange mixture of fury and relief. The document was technical and small, an amendment to a beneficiary designation, a change that removed a name. The amendment had been recorded 6 months prior to Damon filed for dissolution. It was precise in a way that made anger steady. It was the sort of thing people do when they are beginning to rearrange a life in anticipation of a fracture. Yvonne framed the legal theory without jargon. It looks like transfers and changes were made before the filing, not after. We'll ask the court to compel an accounting. We'll show the pattern and the timing. That's not speculation, it's a sequence. She added, we'll ask for full disclosure of Cross Holdings assets and for a tracing of transfers. If money has been moved into that entity with the intent to shield marital value, the judge can remedy that. Kesha listened and felt the familiar work quiet map itself back into place. Ledger, bank notice, signed email. For years, she had kept receipts not out of litigiousness, but out of habit. Now those receipts were our map.
Names reappeared in Yvonne's filing as if in a grid. Julian Cortez, investor. Deposits from an account labeled operating reserve. An amendment entry date. A wire showing several $100,000 moving towards an account that, on paper, belonged to Cross Holdings. Each line was a tiny accusation of intentionality. No one had yet called it criminal in the courtroom. The task was demonstration, not declaration. Subpoenas went out. The defense pushed back with their own motions, trying to narrow the scope. Whitmore, with the same unshakable cadence that could make a complex tax structure sound like common sense, argued delay and invasion of privacy. The back and forth filled pages. But discovery is often a game of endurance, and Yvonne's team had the patience to keep asking. One of the most revealing moments came when a bank produced a ledger marked with a series of wires in amounts that, added up, suggested the company had moved substantial value into Cross Holdings in the months leading toward the filing. The transfer memos were sometimes vague: reserve, investment, and that deliberate vagueness was exactly the point. A ledger entry here, a beneficiary amendment there, and the shape of a plan begins to take form. Yvonne's motion to compel accounting asked the court to make the shadowed things visible. List all transfers, provide account statements for the relevant windows, and identify when and why beneficiary status had been amended. Whitmore's response was surgical. He insisted the transfers were legitimate corporate planning and that Cross Holdings was a separate family asset used for estate purposes. Estate planning does not equal concealment, he argued, carefully separating possibility from conclusion. That had to be true in law. Preservation of nuance is the judge's job. But the juxtaposition of the timing with the filing for dissolution meant the judge would look closely at motive and timing. Depositions followed. Former employees and vendors produced sworn testimony that stitched scene to ledger. Isaiah spoke in more detail about the pattern of the company's accounts, how payroll had been handled with shoestrings and personal covers, how Kesha had been the person to step in when the company's internal accounting lacked a legal buffer. Julian Cortez's emails, now obtained, revealed discussions about capital needs and references to internal transfers. They were careful emails, unreadable to an outsider, but damning in their cumulative effect. All of this changed the tenor of the case. What had been a narrow divorce fight over the division of assets was beginning to look less like a tidy division and more like a ledger of decisions made in shifting light. Yvonne's job was to present that ledger in a way that made the judge see the story its totals told.
That meant charts, timelines, and expert testimony from accountants who could say plainly, here is how money moved. Here is what the timing suggests. Here is what an ordinary business practice would or would not look like. There were nights Kesha sat at her kitchen table and pushed papers into neat piles like someone folding clothes. She learned to speak a new language: trace, beneficiary amendment, accounting order. Yvonne taught her to speak plainly about those things, the same way she had once taught a client to describe a budget without jargon. You don't need to sound like a lawyer, Yvonne reminded her. You need to sound like someone who knows the work. Kesha became precise. She began to rehearse testimony in the mirror, not by memorizing lines, but by summoning scenes. The night she wrote a $47,000 check to keep payroll from failing, the coffee-stained ledger page with her handwriting, the email from Julian, the times she sat in investor meetings translating numbers into human decisions. Memory, guided by documentation, became her ally. The courtroom that convened for the final hearing was quieter than the day the folder hit the bench. The gallery had filled with faces that had reappeared: employees who wanted clarity, neighbors who wanted justice in their sense of fairness, reporters who had watched the story widen beyond a familiar idea of divorce. Cameras were quieter now. Reporters had learned the vocabulary of the case and spoke in low tones. Whitmore arrived with the same polished confidence, but there was a line around his eyes that came from briefing clients, not from moral certainty. Yvonne had organized the hearing into a narrative built on chronology. She opened with a timeline that began with the company's founding and wound through the times when Kesha wrote checks, when payables were late, when an SBA filing listed her as co-founder, and toward the months when the beneficiary amendment had been recorded and transfers directed to Cross Holdings. The timeline was annotated with documents: the ledger with the $47,000 withdrawal, the SBA application with Kesha's name, emails thanking Kesha for keeping things afloat, and the Cross Holdings amendments dated 6 months prior to dissolution. She did not ask the judge to leap, she asked the judge to read. Her strategy was legal, but rooted in the same value Kesha had always known: facts matter. The expert accountants explained in plain terms what the transfers meant in practice, and that Cross Holdings held approximately $4 million in assets connected to the company. They agreed that the amendment removing Kesha as beneficiary occurred before the dissolution filing, and framed that act as a significant fact the court could consider. When Yvonne put those documents on the table, the court's hush returned, but this one was steadier, like the quiet that follows a bell's final toll. Damon's defense attempted alternative narratives.
Whitmore framed Cross Holdings as a legitimate family vehicle, as estate planning undertaken for children and grandchildren. He called experts who spoke to legitimate wealth management practices. But time and timing had a gravity. An estate plan made months before a divorce filing, coupled with transfers sized to create substantial, otherwise unexplained movement of funds, becomes a legal puzzle the judge cannot ignore. Damon's testimony during the final hearing was less sure than it had been in earlier days. He spoke of business choices and the need to protect family assets. When Yvonne asked about the dates and the memos on the transfers, he hedged. Memory is a convenient thing in front of a ledger. He tried to explain wires as reserves and amendments as routine housekeeping. But when the account manager's statements, produced under subpoena, were placed alongside the memos and the amendment, it was harder to make housekeeping sound innocent. The judge's questions were surgical. She asked about the sequence. When did transfers begin? When was Cross Holdings funded? And when was the amendment recorded? Yvonne pointed to the dates and the amounts. Whitmore countered with descriptions of legitimate purposes and the absence of anything the defense could label illegal. The judge did not use inflammatory language. She asked for clarity and for an accounting. It was in that moment, as Yvonne guided the judge through the ledger and the timeline, that the courtroom became the sort of place where public expectations and private papers collided. What the judge asked for was what courts are built to do: a remedy that made the ledger match the lives that had created the value. She ordered a full accounting, giving the defense 30 days to produce a line-by-line disclosure of transfers and assets tied to Cross Holdings. She ordered that the marital estate be considered inclusive of assets that had been transferred during the relevant period, until the accounting showed otherwise. She awarded Kesha an equal division of marital assets, unless the accounting demonstrated otherwise. In effect, a 50% award pending full disclosure. She further ordered that Damon pay $200,000 toward attorney fees, and that the defense submit detailed records to the court. The ruling was not theatrical. The judge's voice was even, precise, the language of remedy rather than moral condemnation. She warned that failure to comply with the accounting order could result in contempt. That last bit of instruction was not a sentence, it was a lever. The judge gave the defense a clear obligation and made compliance a matter of record. After the ruling, an audible shift rippled through the room. The morning's mockery had been replaced by a silence that was less brittle now and more consequential, a silence that recognized process had done some of its work. People exhaled, but not with triumph. They exhaled with the release of tension.
For Kesha, the ruling was both vindication and the beginning of a new leg of work. The 50% finding was provisional, dependent on the accounting. The $200,000 reward for fees helped pay the lawyers who had done what Kesha could not have managed alone. The 30-day accounting order created an administrative race that would force paperwork into the light. Outside the courtroom, the press was waiting. Microphones gathered like curious birds. Reporters asked quick questions that demanded quick answers. Kesha kept her face steady. She let Yvonne speak first, grateful in a way that felt almost private. Yvonne framed the ruling as a step toward clarity. The court required an accounting and ordered recognition of assets that had been obscured. That's the relief Ms. Morrison needed to protect her share. Damon's team framed the decision as an interim step, something that left room to argue. Whitmore said the order required the parties to follow the legal processes and that his client would comply. He did not use words like regret or reconsider. He sounded the way defendants often do, careful, upright, and intent on preserving options. The public's appetite for neat endings is real, but endings in law are porous. Orders invite response. Compliance invites scrutiny. Kesha knew this. She had not come to the courthouse to win headlines. She had come to make the ledger match the life that had produced the company's value. The judge's decision moved that closer. In the weeks that followed, the accounting documents arrived in batches. Some came clean and clear. Others were redacted in ways that invited motion practice. Yvonne and her team methodically parsed them. They identified transfers in amounts that, when aggregated, altered what had been disclosed as the marital estate. Some transfers were legitimate business expenses. Others, the accounting suggested, were directed toward entities that had not been disclosed as marital assets. Each new page was a negotiation between forensic patients and the defense's begrudging compliance. There were tense moments. On a rainy morning, a box of records labeled Operational Reserves arrived with a bank memorandum showing a transfer that had been routed through an intermediary account before landing in Cross Holdings. The route looked like a means of obfuscation. The defense argued that the transfers were routine. Yvonne argued that the timing and method mattered, and the judge ordered further disclosures. Time and again, the court insisted on transparency. In the end, the numbers added up in a way that required remedy. The accounting showed that a substantial portion of value had been moved in the year before dissolution.
The judge's final order, entered after the accounting was filed and after hearings to contest portions of it, reflected what the court had found: an equal division of marital assets with an accounting requirement to ensure accuracy, $200,000 in attorney fees to be paid to Kesha's counsel, and a direction that any transfers made in the period to obscure marital property be considered part of the marital estate unless the defense demonstrated otherwise. The judge also admonished the parties about the seriousness of compliance and warned that attempts to conceal assets could draw contempt, civil sanctions, or other remedial steps within the court's civil power. When the final order was read, a peculiar hush fell over the room, the sort of hush that follows a long process and the sound of a judge's pen closing a chapter. There was no gloating, there was no crowing cruelty. People in the gallery shifted, some with tears, some with stoic faces. The staff who had built the company and watched for months expressed relief that the court had recognized what their daily labor had produced. Damon sat still, his jaw working in a way Kesha now recognized as a contraction of someone adjusting to consequences. The press called it a victory for Kesha. Colleagues called it recognition. Friends called it relief. For Kesha, the ruling meant money and a verified story. She had been a co-founder in practice, and the court had required that the estate reflect that reality. For Yvonne and the team, it was work completed, but also a reminder that equity is a process, precise, slow, and sometimes uncompromising. The aftermath was practical and quiet. Money arrived in a series of ledgered transfers. The court ordered fees, the accounting-based adjustments, and the release of certain frozen assets pending compliance. Kesha used the immediate funds to stabilize her life, pay down legal bills, organize finances, and hire an accountant and a small team to help launch a new professional chapter. She was careful not to rush into public life as a victory lap. For months, she had lived in an anxious architecture of court dates and document requests. Now she had to build something outward from the stability the court had given her. Morrison Financial Consulting began in an office with warm paint and a second-hand coffee maker. Its name was not shouted from billboards. It was inked on a modest plaque near a window that looked out over a street where delivery trucks and mothers with strollers passed by. Kesha hired 2 colleagues she knew from the startup days, a bookkeeper who had a soft laugh and a capacity for rigid spreadsheets, and a former engineer who had learned numbers and storytelling at the same time.
The first month was modest. A local nonprofit needed help untangling payroll records. A woman launching a product line wanted a budget built that would let her sleep at night. Kesha chose clients carefully.
The firm's first projects were prosaic and purposeful, helping small founders understand capitalization tables, helping women who had been co-founders but whose names had faded into press releases reclaim their financial narratives. Her experience had shown her a gap, not just in access to capital, but in the language of evidence. Kesha taught clients how to gather receipts, manage payroll transparently, and identify early ownership that could later become legally significant. Media came later, not with tabloids but with thoughtful profiles. A business magazine's feature framed the arc simply: a co-founder who refused to be erased and rebuilt a practice to help others avoid the same fate. Podcasts requested interviews, in which Kesha spoke not like someone announcing triumph, but like someone explaining a method. Keep records, do the work, make the ledger honest. She spoke about the $47,000 she had once written as an act of necessity, and how that single check had become key evidence in a case that many would have expected a lawyer to win for her. The $50,000 offer from early in the case was often mentioned as an insult shorthand, a number that clarified the mismatch between what was offered and what had been built. Friends noted that Kesha's posture had changed. There was a steadiness that comes from having one's effort acknowledged in formal terms. She still wore the navy suit on occasion, but it was mended now, the frayed cuff tucked, as if the garment had earned the repair. In meetings, she was precise, kindly impatient with excuses that substituted gloss for substance. She offered pro bono consultations to a few women who could not afford counsel, and later developed a small scholarship fund from her firm to help early-stage founders meet accounting costs. Morrison Financial Consulting grew slowly and deliberately, reflecting the way Kesha had lived her own life, one thorough action at a time. There were quieter returns as well. Isaiah rejoined the company briefly as a consultant, wanting to ensure that the technical legacy of the product was stewarded responsibly. Camille became an advisory voice, helping Kesha develop materials that translated tech speak into budget language. Together, they launched community seminars on financial documentation for founders, particularly women, where Kesha told the story of ledgers and checks not as grievance but as instruction. The story's final public chapter arrived in a short documentary segment aired months later. In it, Kesha walked through her modest office, pointing out a bulletin board with post-its and bank statements, vendors' cards, and photographs of earlier days. She spoke about the small acts that make companies run, paying attention to vendor emails, keeping records of conversations, insisting on signatures.
She spoke about the silence that had come in the courtroom the day the folder arrived, how it had been brutal because it carried recognition, and about how that pause had become a hinge in her life. "I didn't expect applause," she said. "I expected to be dismissed." The silence was the first acknowledgement that someone had been listening. Not everyone agreed that litigation is the right path in every case. Kesha never suggested filing suit as a universal remedy. She often counseled that prevention, clarity in ownership documents, open conversations about titles, and timely legal advice is preferable. But she also knew that the labor of collecting evidence and insisting on accounting had restored a financial reality that would otherwise have vanished into corporate gloss. When people asked whether she had wanted a confrontation, she would shake her head. "I wanted accuracy," she said simply. "I wanted the record to match the work." At a small celebratory gathering after the final order, Yvonne raised a glass and said, "You kept receipts, Kesha. That's what won this." It was a toast that felt as ceremonial as any. Damon did not attend the gathering. He was, by then, someone whose public face had softened with the knowledge of consequence. The story's moral was not revenge, but recognition. The court did not humiliate, but required accounting. Time settled. Morrison Financial Consulting added staff and moved to a slightly larger office. Kesha began speaking at industry events about co-founder agreements and documentation. She mentored young women who were building products and who could be tempted to let titles be decided later. She told them to decide now, write it down, and keep copies. The long arc of the case remained a lesson in small work made large. The $47,000 check that had once been a lifeline for payroll had become a piece of evidence that, when combined with the SBA filing and the ledger, reshaped a courtroom's sense of who had built what. The cross-holdings amendment and the transfers to that Delaware entity, dated 6 months before dissolution, had compelled the judge to order an accounting and to include those assets in the marital estate pending disclosure. The $200,000 award toward attorney fees had eased the immediate financial burden of representation. The 50% division ordered by the judge reflected a core judicial recognition that both labor and legal title matter in marital asset division. There was one scene that endured in Kesha's memory.
the silence that followed the folder's arrival at the bench. It had been, she realized, brutal, because it stripped away 1,000 small assumptions. It made people stop and look. It made a record speak where people had assumed the story was already decided. But silence, once followed by action, becomes a tool for remaking.
On a quiet afternoon months after the final judgment, Kesha walked back into the courthouse, not to litigate, but to file a simple corporate registration for a student-run fund she would later sponsor. The security guard recognized her and offered a small nod. She walked up the same steps where the laughter had once greeted her, and the memory of that sound felt distant and thin. Inside, a clerk smiled and asked if she needed help. Kesha signed a form with a hand that had been steadied by fights and by small victories. Outside, a breeze cooled the pavement. When people told the story now, they tended to tell it in 3 beats: the laugh, the folder, the silence. But Kesha would add a fourth: the work that follows the silence. The legal orders did not fix everything in a flash. They opened windows where ledgers had been closed and provided a mechanism by which truth could be established through paper and accounting. For Kesha, that mechanism allowed her to step into a life where she could both vindicate what she had done and build something that would prevent others from being erased. She thought about the $50,000 offer early in the case, the gesture that had stung because it did not match the scale of what had been built. She thought about the $47,000 check she had written, and the nights she had sat up tracing numbers. She thought of the amendments and the transfer memos that had once been invisible. In the end, the court's orders were a ledger's translation into remedy. Kesha's last public line in a recorded interview came calmly. She leaned on the office window and watched a delivery truck back into an alley. "You don't have to be loud to be present," she said. "Sometimes presence is paperwork, persistence, and the patience to make a record." The courtroom's final silence, the one that followed the folder and later the judge's pen, had become for her the kind of silence that heralds action, a pause before the difficult work of reconstruction. The laughter that greeted her at the door had been a momentary dismissal. The silence that followed the evidence was brutal in its clarity, yes, but it also became the axis on which a new life and a new purpose turned. If the story has a clear consequence beyond legal rulings, it is this: erasure cannot survive a steady hand and careful paper. The systems that favor voice can sometimes be balanced by systems that favor traceable labor. Kesha's case did not rewrite laws. It did, however, show how diligence, evidence, and solidarity, the pro bono counsel who stood with her, the witnesses who told what they had seen, the auditors who traced transfers, can produce not only justice in a courtroom, but a blueprint for rebuilding. She closed her office each evening with a small ritual. She would sort a day's receipts into folders, note the next day's priorities, and turn off the light. Outside, the city wound down. Inside, a plaque read, "Morrison Financial Consulting," and beneath it, in a font plain and steady, a line that Kesha had asked to be added: "For those who build." The words were not about a legal victory. They were about recognition rendered in the simplest terms she knew: documented, accounted, and finally counted. If this story moved you, share it with someone who needs to hear it, and subscribe for more. Tell us, what would you have done if you were in Kesha's shoes?